to cover today is administrative law. And what administrative law is it's the body of law that governs the way agencies make and implement decisions. It's basically the rules. We're going to be, over the next couple of weeks, talking about the OSHA Act, the OSHA Review Commission, and some important Supreme Court and District Court cases dealing with how OSHA has to do business. So we're going to start off with basically a framework here that talks really about the rules that agencies have to play by. So administrative law is the body of law that governs the way agencies make and implement decisions, and it has its origins in the legislative branch of government, the executive branch, and the judicial branch. What we're going to do is provide an overview of the administrative system, highlight the relationship between Congress, the agencies, and the courts, and get a basic understanding of administrative law, of why it's necessary, and how a regulatory system operates and functions. This will provide us with some information about administrative procedures and a conceptual basis from which we can analyze and understand a given regulatory system. In particular, we're going to be discussing OSHA. I'm going to break this talk into 4 different areas: the constitutional basis for labor safety and health regulations, administrative rulemaking, access to the administrative process, and the role of the courts in reviewing agency decisions. We'll start off with a constitutional basis for labor safety and health regulations. First of all, administrative agencies, like OSHA, are created and directed by the legislative branch of government, operated by the executive branch of government, and subjected to review by the judicial branch of government. And one of the links that I have available in this section is to the Thomas website from the Library of Congress. And that link goes directly to a website called How Our Laws Are Made. And if you need a little bit of review on how the process works, I would like to refer you to that website, because it takes you step by step through the process of how a bill becomes a law. But simplistically, something like the OSHA Act is going to be proposed by someone in either the House or the Senate. It's going to go through committee, be voted on in committee, go out to the entire floor, be debated, voted on by the House, similar versions voted on by the Senate, for example. Once both versions are passed, they come together in a conference committee, and if the differences between the 2 versions of the legislation are ironed out, it goes on to the president, who signed it into law. And once it becomes a law and a new agency like OSHA is created, then it's operated by the executive branch of government, and they do the day-to-day things, like they will appoint who's going to be in charge of it and things like that. And any decisions that they make are ultimately going to be subjected to review by the courts. And so we're going to be covering how that process works, and in particular with OSHA, over the next couple of weeks. But before we begin that, I'll be talking about each of those areas of direction from the legislative, executive, and judicial branch, but I think it's kind of useful to put some players behind this, sort of know some people. So this lecture is being recorded in October of 2014, and these are the people who are currently serving in these different capacities in the legislative, executive, and judicial branch. And I'm going to click on the link for the judicial branch, and since we're in Kentucky, I'll close out this select your district. But this is our current Kentucky legislators representing us into the United States Senate, the United States House of Representatives. And again, this is October. We have an election coming up in a few weeks. It could be very different after the election. But right now, Mitch McConnell and Rand Paul are our 2 United States senators. And our representatives are Ed Whitfield, Brett Guthrie, John Yarmouth, Thomas Massey, Hal Rogers, and Andy Barr. And so when legislation like the OSHA Act was originally proposed in Congress, it was people like this that debated it and ultimately voted on it. Then you have direction from the executive branch, and once this is a bill signed into law, creating an agency like OSHA, it's going to be run day-to-day by the executive branch of government. And let's take a look at who those individuals are currently. Again, this is 2014. The president is Barack Obama, and the president has a cabinet. The cabinet are members that he appoints, and are confirmed by the Senate. And you probably know some of the cabinet members from areas that aren't really involved in safety and health, like the Department of State. Secretary of State's John Kerry. Secretary of Defense is Chuck Hagel. And then let's go to areas that are relevant to some of the things we'll be doing in this course. The Department of Labor, that's where OSHA is housed. The Secretary of Labor is currently Thomas Perez. And the Department of Health and Human Services, which is where NIOSH is housed, the Secretary of Health and Human Services is Sylvia Burwell. So those are the people that are running things from the executive branch of government. And if any agency decisions undergo judicial review, they go through different processes through the federal court system, but many times they ultimately will end up in the United States Supreme Court. And the members of the United States Supreme Court are currently here. The Chief Justice is John Roberts. He was appointed by George W. Bush as Chief Justice. Anton Scalia is Associate Justice. Anthony Kennedy, Clarence Thomas, Ruth Bader Ginsburg, Stephen G. Breyer, Samuel Alito, Sonia Sotomayor, and Elena Kagan are all currently members of the United States Supreme Court. And we will be discussing a few cases that have gone before the United States Supreme Court dealing with OSHA during the course of the semester. Now, I wanted to start off with direction from the legislative branch of government and what the legislative branch of government does that influences agencies. The first part of this will be the statutory mandate, which I'll elaborate on in the next slide, the Commerce Clause, the procedural mandate, and statutory amendments and informal controls. What's a statutory mandate? It's an act of Congress. When the OSHA Act was signed into law in 1970, that was an act of Congress, and it created a new agency, and this agency had new powers and responsibilities. This formal act, which you'll have an opportunity to read next week, is called the originating statute, and this is a formal directive from Congress that says we're creating this new agency. These are the powers and responsibilities and what this agency is going to have to be doing. Now, there's some problems with the statutory mandate as you read it and look into it a little bit, and sometimes agencies have to administer more than one originating statute, and differentiation between them is not always very clear cut because Congress does pass a lot of laws and some of them overlap each other. But a more common problem, especially with students in the class, is that we'll have a copy of the OSHA Act that you'll have an opportunity to read next week, and it has a number on it. And this number deals with the number that the Act was assigned when it was passed by Congress. Once it's codified and put in the United States Code, it has a different number. So you have to kind of learn the federal terminology system a little bit, which can be a little bit cumbersome and confusing until you get used to it. Now, to create an agency like OSHA, Congress has to have the authority to do something like that. And if you look at the United States Constitution, Article 1, Section 8, Number 3, grants Congress the power to, quote, regulate commerce with foreign nations and among several states. So the constitutional basis for creating agencies that have regulatory powers in the area of safety, health, and the environment are because they affect interstate commerce. If Congress did not make this clear argument, these pieces of legislation would be held unconstitutional by the courts. So the Interstate Commerce Act, the Commerce Clause, is extremely important in creation of agencies like OSHA. Now, the Commerce Clause has been used historically in other places as well. For example, the 1964 Civil Rights Act was passed by Congress, signed into law by the President, and challenged in the courts. And the courts upheld it because Congress had made very clear the relationship between interstate commerce and racial discriminations that were occurring in restaurants. However, in 1995, Congress passed a law that banned firearms within 1,000 feet of schools, and that case went in front of the Supreme Court in the U.S. versus Lopez. And in this case, the Supreme Court said that Congress failed to establish a relationship between interstate commerce and the regulated activity, and therefore the law was held unconstitutional. So those are just some examples of some fairly high-profile pieces of legislation that have either been upheld or remanded based upon the Commerce Clause. And again, it was the Commerce Clause is the basis for the constitutional basis for the creation of agencies like OSHA. Now, the other thing that the legislative branches has to be involved with is the procedural mandate, and this are rules basically that tell federal agencies what they have to do, as well as general directorial procedures from other statutes, i.e., the rules for quote how decisions should be made. One of the most important pieces of federal legislation that deals with direction from the legislative branch is the APA, or the Administrative Procedures Act of 1946. This gives agencies the procedures for rulemaking and adjudication. It provides an overview of what judges are going to have to look at for any decisions that agencies make, and it provides citizen access to administrative and judicial process. And this is, again, a very important piece of federal legislation, and most agencies, like OSHA, have to follow what the APA dictates in terms of how they do business on a day-to-day basis. Now, there are other pieces of legislation that have been passed subsequent to the Administrative Procedures Act, which also deal with, give directives to how agencies must do business. One of them is the Freedom of Information Act, and this requires agencies to make most of their internal documents available. The second is the Sunshine Act. This requires agencies to make any meeting open to the public. You can't do business in a dark corner somewhere. You have to make sure that everybody is allowed to participate. The Federal Advisory Committee Act. These are procedures involved for the agency's use of outside advisors. I've personally been an outside advisor for a couple of different federal agencies, and there are we have to follow certain types of rules to be involved with these committees that are, and the rules are established in the Federal Advisory Committee Act. And then the Privacy Act, which gives private citizens access to agency documents and information about them. Another important directive from the legislative branch is the NEPA, or the National Environmental Policy Act. And in this, it states that all federal agencies must prepare an environmental impact statement before any major action. Now, the next area of this is a task for agencies and courts for reviewing an agency's decision. This is, the agency does something, they make a decision, and it's challenged in court. And the courts are going to have to review what the agency did, whether it was correct or incorrect, and what are they going to do to make this decision. Well, the first thing they're going to do is try to carry out the intent of Congress if the language is clear and unambiguous. So if Congress says the agency is supposed to do this, and they did that, it's clear and unambiguous, and they were going to side with the agency. However, if the language is unclear and ambiguous, and we'll talk about examples of that in a couple of weeks when we get into some specific cases that they reviewed. For example, the word feasible, what does it exactly mean? And the courts had to struggle with that a little bit. But when they do that, they follow a process. And what they'll look at is the legislative history. And most acts, including the OSHA Act, have gone through a fairly extensive legislative history. The OSHA Act was proposed for at least 10 years before it was finally accepted by both the House and Senate, went through conference committee, and signed into law by the President. Therefore, it had a record. And this record consists of prior drafts, reports of congressional committees, record of floor debates, things like that. And courts will actually review all of that and try to then determine, when Congress said the word feasible, what was actually meant by feasible based upon looking at this information that they can find in prior drafts, reports of congressional subcommittees, and a record of floor debates, etc. Now, let's say there's a problem here, that an agency does something that Congress doesn't like. What can Congress do about it? Well, they can do two things. One that they can do is they made the law, they can change the law. So this is what's called a formal control, where they can actually amend the statute. They've passed the law before, and they can go through and propose an amendment. Now remember, to do this is going to be something that is going to have to go through the same process if a bill becomes a law. And again, if you don't remember that process, I'd encourage you to go to the Thomas website and read how our bills become a law, because it does emphasize what a long, difficult battle this can be, because the amendment will have to go through committee, be be approved by the House, voted on to the Senate, go to conference committee, go to the president, just the same way. So this is not something that's typically done that often. There are some examples of that. The Clean Air Act amendments of 1990 are an example of a formal control that worked, but the most of the time, formal control is something that is not done due to the cumbersome nature and the difficult battle that it will take to actually amend a statute. What's more commonly done is what's called an informal control. And Congress does this a lot, actually. If you remember Hurricane Katrina, the agency head who was in charge of FEMA was brought before the floor of the Congress and chewed out, and that was all splashed on national television. And this is something that's pretty common, that Congress will call in a head of an agency and give them a tongue lashing in front of the news reporters so that they can get a lot of media attention. They can also use committee hearings to bring in agency officials and admonish them. And again, this is commonly done, but the biggest stick that Congress has is funding. Congress actually spends the money, and so they're in charge of the annual budgets for any agencies, and therefore this carries quite a bit of weight when agencies are doing something or not doing something. Congress can tie in their budget to what the agency is doing. So this is actually a pretty powerful tool to influence what the agency does. So that's the direction from the legislative branch. The next part that I wanted to talk about, and this is brief, is direction from the executive branch. And then we'll continue with direction from the judicial branch. But this is just one slide on the direction from the executive branch. What the executive branch can do is they appoint the people to run the agencies. And currently the president with OSHA, which is in the Department of Labor, will appoint the Secretary of Labor, which is Thomas Perez, to run the Department of Labor. Within the Department of Labor, there are certain agencies, one of which is OSHA, and the president appointed David Michaels to run OSHA. And so the president has quite a bit of power in appointing who is going to be the top decision makers in each agency. And they are going to follow the philosophy that the president has. And when these people come into these positions with agencies, they tend to be generally running a 4-year term, maybe an 8-year term. It kind of depends, but typically they change with each presidential administration. But they only have a limited number of years to do something, and so they try to target what they want to do philosophically with the brief time that they'll have in charge of an agency. And so this is a very powerful tool that the executive branch has in terms of appointing people who are going to be running the agencies. The second is money. The president talks to each of the agency heads and asks them, how much money did you spend this last year and how much do you need for next year? And the president then will approve a budget before it's sent to Congress for final approval. So the president also has quite a bit of power in terms of the budget by recommending budgets, but again, ultimately Congress will appropriate the money. And these are a couple areas that the executive branch is involved in. Now, got a little bit more information here on direction from the judicial branch, and we'll be taking an entire week talking about specific direction that OSHA has gotten from the judicial branch in the past, but this is just sort of a basic overview on what the judicial branch actually does. The courts will ultimately determine the meaning of any particular statute or constitutional provision, and this is important. They can invalidate an act of Congress if statutory language violates the Constitution. And this means that agencies have to do what the courts say. But the courts do have some limitations. They cannot act unless someone brings a lawsuit. The next part of this is administrative rulemaking, and this will again be getting into some of the role of the courts a little bit later, which will be I'll spend a little bit more time on than I did on the last slide. Agencies carry out their statutory mandate by promulgating regulations. If you're not familiar with that word promulgating, it's a big word that means creating regulations, but the formal way of describing that is regulations are promulgated when they're created by an agency. Now this process means that the regulations are first published in the Federal Register, then they're codified in the Code of Federal Regulations, and they become the force of law unless successfully challenged in court or in Congress. Agencies have quite a bit of authority. They essentially perform legislative, judicial, and enforcement actions on their own. Their legislative actions are they create the rulemaking and set the policy. Enforcement, the agency itself goes out and does the inspections and citations. And adjudication, there's a process intra-agency that can settle disputes that arise from different enforcement actions. And as we'll talk about in a couple weeks too, the OSHA Act gave an additional adjudication for OSHA citations that cannot be resolved within the agency. The Act created a review commission, which gives citizens and businesses an opportunity to dispute the citations before going into the federal court system. And we're going to go through that in a couple weeks in some cases that have been resolved within the OSHA Review Commission. Now, how this works is the agency must publish first a general notice of proposed rulemaking in the Federal Register. This will list some information such as the time, place, nature of the rulemaking procedure, what legal authority they have for the proposed rule, and basically what's in the proposed rule. And this is step number one. Now, how do agencies go about making rules? There are two processes that are established in the Administrative Procedures Act. One is formal rulemaking and the other is informal rulemaking. All agencies will make rules by an informal rulemaking process unless specifically required by Congress to use formal rulemaking. And in formal rulemaking, a trial-like hearing is done where people will testify under oath when creating the regulation or rule and be subject to cross-examination. Most agencies like EPA and OSHA follow what's called an informal rulemaking process. And this is where they publish in the Federal Register a notice and comment that they're going to go about making a new rule and invite anybody, any interested parties, will have an opportunity to participate. And the standard for judicial review when rules are made under the informal process is arbitrary and capricious. And that simply means that you gave everybody who was involved an opportunity to participate. If you're going to have a regulation dealing with electric power companies, you don't want only to tell people who work in electric power companies about the proposed regulation. You have to give everybody an opportunity to participate. And if you don't do that, then the new rule can be said to be arbitrary and capricious because individuals who were not given an opportunity to provide their opinions. The next part is access to the administrative process. And I'll cover initiation of rulemaking, access to agency proceedings and records, access to advisory councils and committees, and access to the courts. The initiation of rulemaking is established in Section 4E of the Administrative Procedures Act. This requires every agency to, quote, give an interested person the right to petition for the issuance, amendment, or repeal of a rule, and this is an opportunity to prod an agency. Now, many of you may do internships or jobs or see situations where you say, OSHA ought to have a regulation about that. And that's what this covers with Section 4E of the APA. It gives you, as an individual, the right to petition an agency to either come up with a new regulation or to repeal one. Now, as a practical matter, if you want to do this, you could probably write a letter to David Michaels and say, you've got to come up with a regulation on this particular or a new standard in this particular area, and you'll probably get a nice letter back saying thank you very much for your concern, but we only have so many dollars and we're doing what we can. So you'll probably just get a nice thank you note. If you want to be more effective on prodding an agency, my recommendation would be to work through your professional associations like ASSE or AIHA, because if you get a little bit more numbers behind you, you will probably have a little bit more success in prodding the agency, although that may not necessarily happen, that you'll be successful. But professional organizations are probably our best method for trying to prod an agency to do something. And again, that's just my opinion. Access to agency proceedings and records. There are the three statutes that we talked about earlier, the Government Sunshine Act and Freedom of Information Act and Privacy Act, all give access to whatever the agency does. And access to advisory committees. The Federal Advisory Committee Act requires committee meetings to be open and balanced in terms of viewpoint. And this act covers both formal and informal advisory committees. And again, I mentioned I've been on several of these, and these are very useful tools for science and technology issues because agencies tend to not have the available expertise to address some of the technical issues. So they'll bring in people from academics or from industry or consulting in different areas that are pretty state-of-the-art on a lot of these issues, and they'll ask their opinions. And when you're on these, it's they are open. Your membership is generally put in the Federal Register or somewhere on the advisory committee, somewhere on the agency's website, and people have an opportunity to comment on whether or not you should be good on that or not. And generally, you're interviewed, and you have to go through a discussion on conflict of interest and things like that to serve on advisory committees. But all of that is established under the Federal Advisory Committee Act. Then access to the courts. The public has a limited right to seek judicial review of an agency performance. I.e., if OSHA does something and you think it's wrong and you want to sue the agency, it's going to be a difficult battle to do that as an individual. One of the first things that you have to do is establish standing. And standing is, quote, a person suffering legal wrong because of an agency action or adversely affected by an agency action within the meaning of the relevant statute is entitled to judicial review thereof. So, in other words, you have to demonstrate that you have been personally wronged by the agency decision before the courts will grant you access to hear your plea. And there are other factors to consider as well. Money. Even though there has been federal legislation to try to help people pay for the costs of lawsuits, they're still expensive. The type of lawyers that will help sue agencies are generally found on K Street in Washington, D.C., and they cost a considerable amount of money to go and defend a position. So going in through a lawsuit is pretty expensive. And there are some provisions within federal legislation where you can bypass an agency and do a citizen suit directly. TSCA allows this, but again, Congress has made it very difficult to establish standing in these cases, so it's a very difficult uphill battle to actually sue an agency as an individual. The last topic that I wanted to talk about is the role of the courts in reviewing agency action. There are some limitations that the court can put on the authority of an agency. Congress can reverse an agency's decision if it violates the originating statute, other applicable federal legislation, the agency's own rules and procedures, the administrative common law, or activity beyond the limits of the Constitution. And an example from this is activity beyond the limits of the Constitution. One of the early Supreme Court cases with OSHA involved, it's called Marshall versus Barlow, and you can find this as 46 U.S. Supreme Court case 307 in 1978. But what happened is this was an electrical company in Pocatello, Idaho, and an OSHA inspector this is back in the early days of OSHA. They were trying to determine, okay, we're supposed to make sure that there's safe workplaces. How are we going to do this? And the regional area director thought, okay, we'll have a sort of a scheduled inspection. We'll just go to different businesses within our jurisdiction and go in and make sure that everything's fine. So they went to Barlow's electrical place in Pocatello, Idaho, and the president there, Mr. Barlow, came out and said, do you have a search warrant? And they said, no, we don't. He said, has anybody complained about anything going wrong with my company? And they said no, and he sent them away. And this became a case that basically Barlow refused an OSHA inspector admission because the Fourth Amendment protected U.S. citizens against against unreasonable search and seizures, and they needed to have a search warrant. And the Supreme Court actually upheld this. So what this meant from a legal matter is that warrantless searches are not allowed in the United States. But as a practical matter, if an OSHA inspector shows up and wants to come in, you can tell them to go get a warrant, and they'll go get a warrant and probably come back with a different attitude than if you are friendly to them and let them take a look at things at first. But this was an important Supreme Court case that was established in 1978, where OSHA had gone beyond the limits of the Constitution and trying to do a warrantless search for no cause, when there had been no complaints, no accidents, no anything. The other things that agencies can do is they can strike down, the courts can do, is they can strike down an agency decision that violates a statutory or constitutional provision, and they play a very important role in reviewing and shaping decisions that agencies make. And we'll talk about this a little bit more in a couple weeks with specific examples of why agencies do things the way they do based upon what the courts have told them. But they also use the Administrative Procedures Act to examine the factual basis for agencies' decision. And when they do a factual review, they look at whether or not the rule was made by a formal or an informal making process. And when they review this, the courts will, if it's made by an informal process, and this is the notice and comment rulemaking where all interested parties were involved, if the courts determine that the agency did not invite all interested parties or ignored information from one interested party, etc., they can set aside an agency decision that's, quote, arbitrary, capricious, or abuse of discretion. And this is a judgment call, and we'll go through the asbestos case in a couple of weeks, where the courts kind of define this a little bit more clearly. But it is, as long as agencies give all interested people an opportunity to participate in the rulemaking process, courts will generally side with what the agency has done. Now, formal is a little different. A formal control is when an agency, this is again where rules are made by having some kind of a court-like, trial-like atmosphere, where the agency is under oath and subject to cross-examination. That's a different review process, and in that case, the courts will set aside agency actions that are, quote, unsupported by substantial evidence. You can kind of think about this as, I think a good analogy is what occurs in a civil trial and in a criminal trial. And sometimes cases are not supported in a criminal trial, because in a criminal trial the bar is beyond a reasonable doubt. So you can have cases of people who are charged with a crime, and they are not convicted of that crime. The jury says that no, we're going to let them go because we have a reasonable doubt about their guilt or in this particular case. Whereas they can subsequently be sued in a civil court and lose a lawsuit. You scratch your head and say, well, why could that happen? How could they be found innocent in a criminal trial and guilty in a civil trial? And the answer is that the standards are different. And that's the same thing that occurs here with the difference between unsupported by substantial evidence and arbitrary, capricious, and abuse of discretion. It's basically the same type of differences you'll see between the evidence that's required in a criminal case or in a civil case. The bar's higher in a criminal case, and again, it's higher in a formal review case. Now, what some agencies will do, and OSHA is one that does this, is it does a hybrid rulemaking process. And the reason that it does this is it's trying to protect itself when it goes to court, like it knows that it will. And it is charged with Congress for doing an informal rulemaking process, and sometimes courts may have a higher bar. So what OSHA tends to do is provide an opportunity for all interested parties to comment, and then give other people an opportunity to have a hearing, and they'll be sworn in and subject to cross-examination. So they kind of do both, and this is a hybrid rulemaking process. And And this then gives the agencies a little bit better uh, protection when they go into court, because then they'll have a clear factual basis, and they're going to be in a better position when they undergo judicial review by going above what Congress has mandated that they actually do. And that's kind of what this hybrid is. They're doing something beyond what Congress requires, because then they know that the courts are going to look at them a little bit more favorably. Now, there are limitations in what a court can do. If the courts don't like what an agency is doing, it cannot overturn an agency's decision because it disagrees with the agency's policy determinations. So that's one major limitation. And the policy decisions are going to be set by the statutory mandate, and the courts can't really touch that. And as we'll learn about in the benzene case in a couple of weeks, risk assessment methodologies are extremely useful for agencies to use to support policy decisions, and the courts generally defer to agencies' decisions if they have some kind of a methodology in place for making them. So what we've covered today is administrative law, sort of an overview, the constitutional basis for labor safety and health regulations, administrative rulemaking, access to the administrative process, and the role of courts in reviewing agency action. Next week, we're going to go through an actual agency, and we're going to go through OSHA, talk about its creation, what it does. The next week, we'll get into the Review Commission and how any disputes that cannot be resolved within the agency are adjudicated by the Review Commission before going into the federal court arena. And then the week after that, we'll actually talk about OSHA regulations that have been challenged in the federal courts, and ultimately what that's meant for how the agencies have to do business. But again, today it was administrative law, and it's sort of a rule and a framework by which all agencies have to work, and gives you an overview of how the legislative, the executive, and the judicial branches all play a very important role in this process.